Welcome to this episode of Term Talk, the Federal Judicial Center's video podcast discussing the term's Supreme Court opinions likely to have the most impact on lower courts. I'm Jim Chance, Senior Judicial Education Attorney with the Federal Judicial Center in Washington. We'll be discussing two sets of criminal law and procedure cases this term. In the first, prosecutorial behavior is at issue in Glossip versus Oklahoma, whereas Barnes versus Felix addresses how to evaluate police behavior in a dangerous situation resulting in an excessive force claim. To help untangle these issues, I'm fortunate to be joined by Laurie Levenson, Professor of Law and David W. Burcham Chair in Ethical Advocacy at Loyola Law School, and Evan Lee, Emeritus Professor at UC Law San Francisco. Thank you both for joining me. The facts in Glossip versus Oklahoma are unique in fact and posture. The ruling in this case results in a third trial for the defendant, and the request for a third trial was supported by the Attorney General of the state. Help us understand what's happening in this case.
Indeed, Jim, this is a very unusual case. Richard Glossip was convicted of participating or getting a key witness, Justin Sneed, to murder his boss. Now, it wasn't Glossip who actually beat up the boss with a baseball bat. It was Justin Sneed. And in the first trial, Glossip was convicted, but that was overturned on ineffective assistance of counsel. On the second trial, he was convicted again. And yet Glossip, for 28 years, asserted his innocence and said that he may have helped Sneed conceal the crime, but he did not participate. He even refused a plea bargain. Now, over this time, there was a lot of interest in this case. And in fact, there were two independent investigations to see what happened here. One by a private law firm, the other through the Attorney General. And during that time, all of a sudden, about 8 boxes of new documents showed up from the state to give over to Glossip's counsel. And in those documents, it turns out that the defense found out that the prosecution's key witness, Sneed, had lied on the witness stand because he said that he didn't have bipolar disorder, he had not been prescribed a particular drug by a psychiatrist, and that would have made a difference, not just with his credibility, but also because it would show that he had impulsive outbursts of violence, and that could go to the merits of this case. And let's not forget that this case was a death penalty case. So in this situation, what the documents also showed is that the prosecutor knew, or likely knew, that in fact false testimony had been presented. And under a decision called Napu versus Illinois, that is a constitutional violation. A prosecutor has a duty to correct false testimony that is presented to the jury, and that didn't occur here. So a successive petition was filed on behalf of Glossip to the Oklahoma courts to say that he was entitled to a new trial. But the problem is that the Oklahoma courts didn't want to give him a successive petition. And then there was the underlying issue, what do you have to show for that NAPU violation? How material, how much difference would it have to make that there had been this false testimony presented to the jury?
Evan, Justice Gorsuch recused himself from participating in this case. So what did the other justices say?
Well, before the court could consider the merits, it had to establish its own jurisdiction. Did the state appellate court's holding to the effect that the Oklahoma Post-Conviction Procedure Act precluded relief, did that constitute an independent and adequate state ground that would prevent the U.S. Supreme Court from exercising its appellate jurisdiction? And 6-2, the court rules that it does have jurisdiction. Why? Because, as Justice Sotomayor explains, that procedural ground's not truly independent of federal law, that in order to decide the Oklahoma Post-Conviction Procedure Act question, the lower court had to decide a logically antecedent federal question, and that is the Illinois versus NAPU issue that Laurie referred to earlier. So it's not truly an independent and adequate state ground, and therefore the U.S. Supreme Court has jurisdiction. On the merits of the federal issue, the merits of the NAPU issue, the majority agreed 6-2 with the Attorney General and Glossip that NAPU had been violated. That leaves one more question, and that is the proper remedy. Do you grant a new trial, or do you merely remand to the lower court for an evidentiary hearing? Now, on this question, Justice Barrett jumped from the majority to the dissent, meaning that the remedy portion of this is 5-3. The majority, the remaining 5 justices in the majority, held that a grant of a new trial was justified. The reason that Justice Barrett jumped to the dissenters on this was that she felt that the facts were not so clear as the majority made them out to be, and that factual issues ought to be decided below. Justices Thomas and Alito dissented as to all the issues. They accused the majority of inventing a state court decision on the NAPU issue where it didn't really exist. And on the merits, the dissenters said that the discrepancy between Snead's testimony and the actual facts was immaterial to the jury's conviction and death sentence. So again, that issue that Laurie referred to earlier, materiality, there's a sharp disagreement among the members of the court on that. And finally, they, along with Justice Barrett, argued that Glossip could be entitled to no more than an evidentiary hearing at this point, not a new trial. I might also add that the dissenters made it clear that they consider this case to have been improperly politicized by legislators, the state attorney general, and now the majority of the Supreme Court.
Laurie, what's important for the lower courts to know about this decision?
I think this case is really important because it shows that NAPU type of challenges where there's a claim that the prosecutor either improperly elicited false testimony or knew that there was false testimony presented, prosecutors have a duty to correct that. And as we see more post-conviction discovery come out during the post-conviction phases, it's more likely that you might see situations like this. So I think it's key that the court realize that it's not just Brady violations, not turning over discovery favorable to the defense. It's when you get this information, does it show that a prosecutor violated due process by not correcting false information that was presented?
And there's a duty to do that.
There is an absolute duty to do that.
Evan, would you like to add anything more?
Only that a personal point, which is that this case has been going on in the Supreme Court almost as long as I've been a law professor, which is a long time now, and that would only ever happen in a death penalty case.
In our second case, Barnes versus Felix, it looks at what must be considered when determining whether force used by police is reasonable. Evan, what are the facts of this case, and what does the opinion tell us about what standards should be applied?
This case grows out of Texas, out of the Houston area. On April 28th, 2016, Officer Roberto Felix Jr. received a radio alert about a vehicle in his area. The vehicle had outstanding toll violations. Felix looked for it. He soon spotted the car and he pulled it over. He asked the driver, Ashtian Barnes, for his license and proof of insurance. Barnes said he didn't have his license with him. He left it at home. And he said the car wasn't his. It was his girlfriend's. She had rented it. He did say that he might have some ID in the trunk. So Officer Felix said, well, okay, pop the trunk open from where you're sitting, which he did. And at the same time, he shut off the ignition. So the facts start to speed up now. Officer Felix, with his right hand on his holster, now told Barnes to exit the vehicle. Barnes opened the driver's side door, but he didn't get out. Instead, he very quickly started the engine again. Felix unholstered his gun. As the car lurched forward, Felix jumped onto the door sill, yelling for Barnes to stop. At this point, Felix couldn't see inside the vehicle because his head was above the roof of the car. He then, and this is probably about a period of about 2 seconds from when he jumps on the door sill to when he fires 2 shots blindly into the car, at least one of them striking Barnes. Barnes was hit. He was able to stop the car, but by the time backup arrived, Barnes was dead.
Laurie, tell us about the standard that the court applied in this case.
Don't forget that even though we're talking about this in our group of criminal law cases, this very much is a Fourth Amendment criminal procedure case brought as a civil rights action. And so the court said, when is it excessive force? When has the police officer committed a constitutional violation? Well, the standard we know from Graham versus Connor is whether it's objectively reasonable from the perspective of a reasonable officer at the scene. But the issue is, how much of that scene, time-wise, do you look at? Because there were some circuits that say you just look at the moment of the shooting and decide whether the officer would feel he was at risk. Others would say, well, no, take a look at what started all of this, pulling him over for a toll booth violation, and decide whether that crosses the line. So for the Supreme Court, they're using the Graham versus Connor standard, but they're explaining how broad of an approach they're going to take to it. Well, what they said in this case is you don't look just at that moment. It's not limited just to the moment of the use of force, that you could look at time before it and throughout it to make that decision. And sometimes that will work to the benefit of the plaintiffs, sometimes to the benefit of the officers. For example, the court went on to emphasize that traffic stops are actually some of the most dangerous periods for police officer work. There often is a danger that arises, things develop very quickly, so you have to give some deference to officers who are making spur-of-the-moment decisions. But the officers can look at the totality of the circumstances, and that's what the court will too. Where are you? What led up to it? How fast was someone going? What type of orders were they not following? What kind of force were you using? Now, it's not prescribed exactly how that's going to play out, but it's a broader standard than what was used in this case.
Thanks. Evan, anything you'd like to add?
Well, I think if you look at the narrow holding of this case, it helps to shed light on what might still be to come. The narrow holding being that you can't just arbitrarily limit the totality of circumstances test to, quote unquote, the moment of the threat, that just blocking out time from the consideration is not a correct reading of objective unreasonableness. But what the court does not say is that you can't edit the totality of circumstances for content. More specifically, there's an argument that you shouldn't be able to look at what we might call contributory negligence on the part of the officer in leading up to the danger that precipitated the use of force. And I think that on remand, it's going to be really interesting to see what standard the district court does apply, and then whether this case eventually makes it back up to the Supreme Court, and it has to confront the issue of whether you can have an objective unreasonableness rule that categorically rules out any so-called contributory negligence by the officer.
All right. Thank you both for your time and expertise. It's been a pleasure to be with you.